We wanted to be flight attendants, and it was the best career.
TWA maintained a policy of terminating all flight attendants who became mothers.
I didn't want to stop flying.
Between 1965 and 1970, over 400 female flight attendants for Transworld Airlines or TWA had been fired, not because of underperformance, but for simply becoming mothers. Their efforts to remove this TWA no motherhood policy faced over a decade of reactions from the airline and union. The mothers reformed how airlines view their flight attendants and set new precedents for enforcing women's workplace rights. The story of the no motherhood policy begins in the 1930s. The first flight attendants were female nurses, called stewardesses or hostesses, who comforted passenger fears about flying. By the late 1950s, aircraft improvements meant nurses became less needed. Airline competition increased, shifting the focus to using hostesses to win over customers.
This looks a lot like marketing women in particular as youthful, single, sexually appealing, rather than as professionals.
Job requirements increasingly centered around the young, beautiful hostess, becoming an industry-wide standard.
I took water pills, I took diet pills, I starved.
I had to sign a piece of paper that I would quit at the age of 32. My career was over.
Airlines also grounded pregnant hostesses, justified at the time by safety concerns. However, many fired hostesses after they became mothers. While hostesses do work long hours unsuitable for childcare, airlines likely had a different reasoning, that mothers could not appeal to travelers in the same way a young single woman could. At the same time, early reform attempts started reacting to these airline practices. In 1945, the Airline Stewards and Stewardess Association, or ALSA, was founded. This union increased salaries and limited working hours with multiple airlines. However, hostesses were largely regarded as unserious, short-term workers compared to pilots, so ALSA had limited bargaining power. The 1964 Civil Rights Act boosted ALSA's reform efforts. It created the Equal Employment Opportunity Commission, or EEOC, to address employee discrimination claims. Flight attendants flooded the EEOC with complaints. At a time of second-wave feminism and an increase in female workers, the flight attendants garnered attention from the equal rights movement. In 1967, ALSA compelled TWA to remove their under 32 age policy. Many airlines reacted in opposition. They argued that young single hostesses were necessary to keep their business popular. The 1970 TWA Flight Attendants Agreement did not protect against gender discrimination, despite banning racial, religious, and ethnic discrimination. When men started becoming flight attendants in the late 1960s, the no motherhood policy was not extended to those that became fathers. This double standard appalled many female flight attendants. Hostess Ona Gishin even edited her flight attendants agreement in protest. In 1970, ALSA filed a class action lawsuit to reform the no motherhood policy, combining discrimination claims from over 400 mothers. While age and marriage requirements were overruled relatively quickly, reforming the no motherhood policy faced complicated reactions. The 400 flight attendants argued for their reinstatement and compensation. 2 years later, TWA allowed them to return, dropping the no motherhood policy, but with no compensation for lost wages. A few, like Judy Gerling, accepted this offer.
For me to come back in 72 when I had young children, I also had my parents in Arizona, and I needed to be able to see them because they were getting older and had health issues. Others said, no, I'm going to wait for the lawsuit to prove that I should come back with seniority.
TWA reacted adamantly against compensation. They argued that most of the flight attendants filed their discrimination charges after the 90-day window. The district and circuit courts had opposite rulings, stalling the case for another 10 years and keeping the flight attendants in limbo.
One friend, her husband was a pilot, so it was hard for her when her children were younger to get childcare and work around both her and her husband's schedule. Other mothers that I talked to went through the same thing.
By 1978, TWA's timeliness argument became harder to justify. Other airlines lost similar gender discrimination cases and made policy changes. In a new settlement, TWA gave in, agreeing to compensate all flight attendants with full retroactive seniority.
And seniority really in the aviation world is your whole life. You know, it determines when you work, where you work.
In 1979, this retroactive seniority drew criticism from a third party, the Independent Federation of Flight Attendants, or IFFA. They were ALSA's successor, the union that supported the mothers. Despite this, IFFA took a new stance, arguing that retroactive seniority would make newer flight attendants unfairly lose their current privileges.
There was others who said some of these people only worked 6 months, and now here it is 12, 15 years later, and they're getting their job back with full seniority. I've been working 10 years, now all of a sudden I'm below all these returning mothers.
IFFA appealed to the Supreme Court. The case was labeled Zipes v. TWA after one of the affected mothers. Two questions were posed to the court. Was filing within the 90-day requirement essential, and were the mothers entitled to retroactive seniority? The Supreme Court looked at the Equal Opportunity Act of 1972, which doubled the window to submit discrimination claims. They reasoned that filing dates were not intended to be a strict barrier. In 1982, the Supreme Court held that time restrictions can be waived by courts on the basis of fairness. All the mothers were validated for full retroactive seniority. Other airlines removed their no motherhood policies around the same time as TWA. This made being a flight attendant a more permanent job. Combined with age, marriage, and gender rule revisions, this caused a decreased emphasis on appearance standards compared to safety training. Since Zipes v. TWA gave sweeping compensation to all mothers, newer flight attendants were suddenly demoted in seniority, despite many having more experience. When TWA soon downsized, some of these flight attendants lost their jobs. Though, if the no motherhood policy had not existed, it is likely that the mothers could have achieved this seniority in the first place. In 1989, the Supreme Court ruled that IFFA did not have to pay the returning mothers any legal fees. At a time when strikes became less effective, this reform increased the power of unions to intervene in court. Furthermore, Zipes v. TWA was a landmark decision for all workers. It created more opportunities to file untimely cases on past discrimination. For example, until the late 1970s, it was common practice in some states to fire pregnant teachers. In 1978, the Pregnancy Discrimination Act prohibited such termination, but it could not give retroactive compensation to teachers fired before 1978. The timeliness reforms set in Zipes v. TWA made it easier for these teachers to argue for compensation. Today, while flight attendants can be mothers, the US is one of only 8 countries in the world without a standardized paid maternity leave policy. This leaves the responsibility to individual companies who have few incentives to provide extensive support. The TWA mothers opened the door to raising children as a flight attendant. Reforming the national maternity leave policy would make childcare more realistic for all professions. Eliminating TWA's no motherhood policy reformed perceptions of flight attendants beyond appearance. The legal battle reformed timeliness restrictions after the mothers faced complex airline and union reactions. The mothers, once symbols of traditional gender roles, established a legacy of reforming for equal opportunity.